suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting, Melbourne solicitor, joins you in the studio to take all your legal questions. And believe it or not, there are lines free. I am not lying. 1300 222 774. This is a very rare event, which is why I tell you like this. So if you have a question, call now. Good morning, David.
Good morning, Ellie.
Are you well?
I am indeed. Thank you very much.
You had no homework.
No, so I had the weekend off.
Yes. I'm so glad we could facilitate a rest for you.
I'm grateful. And of course, next weekend's a long weekend, so I have another, well,
just wait
yes.
and see.
Okay.
I'm sure we'll be able to come up with
I'm sure you'll manage something.
to keep you entertained. Philip in, now I'm going to, Devonport?
It's
Philip?
where the spirit of Tasmania parks when it visits Tasmania.
It is. Philip, good morning.
Hello.
Yes,
morning.
hello.
Hi, Philip.
Good morning, Ali. Good morning, David. I have a question about a building inspection report that I organised and paid for before I bought my house a few years ago.
Yes.
It was in 2018, so 5 years ago now. I've been doing some bathroom renovations, and when I looked underneath the bathroom, the plumbing is substandard and was clearly not installed by a licensed plumber.
Yes.
My question is, how long can I make a claim for the building, to the building inspector's insurance if I choose to have that repaired?
Philip, are we talking about a house in Tassie or a house in Victoria?
It's in Tasmania.
Okay. Well, the
Different
answer
rules?
is you need to look at what the rules are there. But as a general principle, the purpose of the building inspection report is to determine whether the building is structurally sound, not to see where... So in Victoria, there's a provision in the standard contract that you can tick if you want a building inspection report. But it's looking for major defects and structural problems. Mm-hmm. And you wouldn't be expecting the building inspector to rip out the bath to make sure that the plumbing's okay. So you need to look and see what the limits are in the report. Right. And then you need to look and see what the Limitation of Actions Act provides in Tasmania. In Victoria, it's 6 years. It might be less in Tasmania.
Right. If the building inspection report scope says that it will report on anything under the house where there is 600 millimetres or less space to inspect, which is what it says.
Sorry, it's more likely to say 600 mil or more rather than 600 mil or less, unless you've got a very thin building inspector.
No, correct, you're right. So given in that instance, I would have expected them to sort of mention this.
I think it's a question of how accessible it is. But again, look very carefully at what the report promises to cover and then make up your mind whether or not, and look at the limitation period. Yep. But in Victoria, if they didn't comply with the terms of the agreement you had with them, then you could damages for breach of contract.
I hate to be cynical, David, but you also have to look at the exclusions, because in my experience, when you do get a building report, there are so many... we can't do this, we didn't do that, this is not possible in the conditions of the report, that it becomes very difficult to say you missed this.
In Victoria, a person is entitled to assume that a certificate of occupancy says it has the effect of saying it complies with everything it's required to comply with. No, just the statement that, yes, it's okay to live in this property. There's no warranty by the person who issues the certificate of occupancy that it complies with the contract or all the laws.
Is that right?
Yeah, disappointing.
It is disappointing. June in Cheltenham. Hello, June.
Oh, good morning. We've just signed a contract a couple of weeks ago to purchase a new home.
Congratulations.
Thank you. And we've been told to take out insurance on the property now. I'm just wondering why we need to insure a property we don't own yet.
Because you've paid a deposit, isn't that the case?
It used to be.
Okay.
What happens to... Well, I haven't seen your contract, June, and I don't know what it says, But the obligation that the vendor has under the law is to deliver the property to you in the condition in which it was inspected, fair wear and tear accepted. Now, prior to that change in the law in the mid-1990s or the end of the 80s, there was a concept called, what the law said was that the risk in the property moved to the purchaser upon the signing of the contract.
Okay.
So it's a bit of both ways. The story I tell is that the house I live in I bought from a mortgagee, and the contract said that the risk in the property passed to me on the signing of the contract. And I can tell you that there was and I insured the property because the risk has passed. In the week before settlement, after I had done my final inspection, but before I moved in, there was damage for which the insurance claim was $182,000.
Wow.
Gosh.
So if you look at taking out insurance 30 or 60 days prior to settlement, then I come along and say, well, you've got a degree of protection that you wouldn't otherwise have, and your house insurance for 12 months might cost you $1,500 to $2,000. I think it's $200 peace of mind. So do you have to? The answer is no. And you have some rights in the event. Your bare minimum right is to avoid the contract.
Right.
But so I come along and say, I recommend to my clients that they take out insurance, but they often get an argument back, but I don't have to. And I just say, you've released the deposit. I just think it's peace of mind.
Yeah.
I mean, what's the average price for a house in Melbourne now is $1.3 million. I just think for a couple $100,
just do it.
just do it.
Yeah, no, that would make sense. Jackie in Bulleen. Hi, Jackie. Jackie.
Hi, Dave. Hello. Hi, David and Ali. How are you?
Well, thank you.
Great. My question relates to a P-plate driver, so a newly minted P-plate driver. We currently take to school the P-plate driver, a 15-year-old brother, and two other children who are aged 17 and 14. Can my P-plate driver take those other children to school?
I don't believe so.
It's only one other in the car, isn't it?
There's difference whether it's family members or non-family members. And what Jackie's talking about is, presumably, Jackie, you're going to sleep in these mornings now, and so it's the sibling and the two friends. I think that breaches the rules. I'd have a look at the road rules, but I'll confirm what the position is next week.
Okay.
Yes.
Sorry to do your homework, David.
No, that's all right. That's a 5-minute job, but I can't do it while Ali's twiddling her thumbs.
No, sorry. We should know that, though, shouldn't we? And also, I don't know, I reckon something in the...
It's a long time since I've been a P-plater, to be honest with you.
It's not that long since I've had to deal with this question. And in the deep recesses of my mind, I think there might even be an after dark rule. I don't know. There's some sort of... Anyway, either someone will text us or David will do it for homework, Jackie. Tracy in Geelong. Hi, Tracy.
Oh, hello. Hello, David and Ali. I live in Geelong and my neighbours have about 10 silver birch trees and about 8 of them are encroaching under the fence and the roots are lifting my paving. If I put in roof guard and the trees become unstable and they fall onto the neighbour's house, am I liable for any damage?
Could be. If you prevent the roots going any further, I don't see there's an issue. But if you're proposing to cut the roots close to the fence line to put in your root guard, to put in the barrier, it may be that the work you do will destabilise the tree. But I'd come along and saying, it's likely that it'll fall on their house rather than yours. But that's very cynical of me, Tracy. So let's not run that one.
Well, in a westerly, the prevailing wind is westerly, and that's where the strong winds come from, and that would blow into their house.
Oh, okay. Well, I'd rather you do it in consultation with them so that there's an agreed course of action.
Yes.
So if they were party to the agreement that it really what you're saying to them is rather than getting a court order that the trees be pulled down, can we agree that this work will be done? And you might, as we talked about indemnities a couple of minutes ago, you might say, and I want a release for any damage that might be caused to your house should this have effect in destabilising the trees.
Excellent. I've just written that down. Thank you.
Good on you, Tracy. And look, because we don't want to give you homework over the long weekend, David, Kelsey has, I'm assuming it's Kelsey, behind the glass, has done a wonderful job. Oh, Jules, who's looking at me as if to say, yes, it was Jules. Just the team behind the glass who keep this program on air have told me, and you, David, that from the Vic Roads website for P1 licence holders, so they're the early newly minted, it's called Peer Passenger Restrictions, and you can't carry more than one peer passenger aged between 16 and less than 22 unless you're a member of the police force, driving an emergency vehicle for work, driving an emergency vehicle in line with any contract terms, driving with a full licensed driver sitting beside you, or granted an exemption from the restriction. So you can't carry someone between 16 and less than 22. But that's peer. Family is a little different. So maybe there is still some homework for you, David.
Okay,
sorry.
all right. Or Jackie just doesn't get the sleep in until this gets resolved.
Poor Jackie. And I've also got a text here from David, another David, saying, I remember David Whiting, talking about his house insurance. I've been listening that long. Love your work.
Like a mere 12 years ago.
But what we didn't ask you, and maybe this is too personal, but more than $100,000 worth of damage.
$182,000.
What happened? Fire, tree?
No, no. It was deliberate damage.
Okay.
And what happened was that somebody came in and took the doors. So they took a shower screen. Why you take a shower screen is beyond me because they're all fitted. They took the kitchen cupboards, but not the carcass. There were a couple of appliances that went. There was just a lot of work that needed doing, and it took 5 months to get fixed.
Gee, okay. Okay, that's as good an ad as any for taking out insurance. Wayne in Red Hill. Hi, Wayne.
Hello, good morning, and thank you for taking my call. My mother has an existing will which was purchased in the form of a kit from Australia Post or somewhere like that.
Yep, you buy them at newsagents and buy them at the post office. Yes.
Yep. And over a period of time, addresses have changed and so forth, so we're looking at updating it. Can you tell me if those wills that you purchase as such would stand up to the challenge?
Wayne, you have to make up your mind whether or not, let's assume the will has been done perfectly, right?
Yeah.
They stand up to challenge. Where they fail from time to time, where every will fails time from time, is that you've got a particular circumstance that you haven't covered, or you haven't provided if somebody dies, or if there's a gap in the estate. So your mum might write a will that says, I leave the house equally to my 4 children, but she doesn't say what she's going to do with the money that she's got in the bank, because on the day she prepared the will, she had very little money in the bank. If you were leaving some money to somebody called John Smith, then my friend John Smith, we may have an argument about who friend John Smith is. I'm not worried about the addresses. So if she was leaving money to my son Wayne of Red Hill, I don't think there's a doubt about who we're identifying. And if she made the will when you lived in Cheltenham, it wouldn't make any difference.
Okay.
Right, so don't worry about addresses. Just make sure that the people are adequately identified so that the executor has no doubt who the gift is intended for. And if your mum moves, that she doesn't need to make a new will just because she's moved.
No. Wayne, thank you. Viv in Seymour. Hi, Viv.
Hello. My car was making a tapping sound, so I took it to the mechanics and they said it was going to cost $3,100 to fix it. It was quite involved and a lot of man hours. So I left it with them, and when I went to pick it up, it was still making a tapping sound. And I said, well, I'm not prepared to take it because
you haven't the symptom of the problem is still there, yes?
Yeah, well, they seemed to think or said that they'd fixed a problem. Anyway, so I didn't take it, and a few days later the whole yard got flooded and my car was written off because it had water up to the steering wheel.
Yes.
Anyway, now they're giving me a bill for $1,300 for parts
that were put in before it was flooded.
Yeah, correct.
All of the evidence to date is they haven't fixed the job that you went there for. So why would you be paying any amount of money for a job that, on your view of the world, they didn't do?
Well, that was my insurance paid out, and they're aware of that. And I think that they're thinking that
You've
I
now got
paid out.
cash.
They did make a comment that their insurance hadn't paid and they'd lost a lot of money through the floods, and I was like, well, didn't you have insurance? And they said it hadn't. Their insurance companies hadn't paid.
Or they didn't have enough, or whatever it is. Yep.
Yeah.
I don't believe there's no evidence at the moment. There's evidence they bought the parts. There's no evidence that they completed the task that you contracted them to do, and it's now impossible for them to do it. So I can understand they'll be out of pocket the $1,300. Whether you pay it or not, I think it's entirely up to you.
Well, they said that it was they've taken the man hours off it, but they're charging me for the parts.
Same issue. I think it's entirely discretionary whether you pay or you don't.
Viv, there you go. Margaret and Bowen, an unusual query, I think. Margaret, good morning.
Good morning, thank you. I'm running a tutorial centre on the first level of an office building, and in September, dental laboratory came on, and there was we have the same air conditioning system, and so whatever fumes and everything from there comes to my side.
Yes.
There was even furnace malfunction, and the whole place was filled for almost a whole week. Now, I complained to the agent. Agent just dismissed or was intended to push me out of the place. Then, in the end of January, a letter came from the council looking for the permit or objection. The permit was put in by the dental laboratory, and then I put in my objection. Now, I got a response from the council. They gave me something from the land use. The land use was saying, it's actually the dental laboratory is under discretionary, which means they can approve if they want. I gave them all the risk associated with dental laboratories. And one of the officials came to me and said, "But you got your information from online. How do you know it's true? It could be just..."
So Margaret, what are you trying to achieve?
I'm trying to find out if I have to go to VCAT. Is it the owner of the dental laboratory or the agent or the council?
It's okay.
Yes.
It depends upon what the council does. If the council, what will the council do? One of two things. It will either refuse the permit or give notice of intention to grant a permit. If they refuse the permit, the person who goes to VCAT is the dental laboratory, and they need to persuade VCAT that they should be able to carry on that business in that activity. If the council issues a notice of intention to grant a permit, it's saying to you, we are going to approve this use, and if you want to continue to oppose the use, then it's necessary for you to go to VCAT, because council says we're going to. If you want to stop them, you have to make the VCAT application.
Right.
And that's against the dental.
Yes, in a sense, it's not like the fact that council got an objection means that the use won't proceed. It's the council does an assessment, and if they think it's appropriate, then they issue a notice of intention to grant a permit.
Margaret, good luck. Peter in East Melbourne. Hi, Peter.
Hello?
Yes, hello.
Yes, I'm still here.
Good. Well, what do you want to ask David?
Oh, hi, David. I'm on the air. My mother's property in Malvern East, there's a large tree next door. It's got to be maybe 15 metres high. And last year, during strong winds, one of the branches fell down and took out the power line in my mother's property. Now, to repair, the electricity company came out, reconnected, but they didn't nail back the weatherboards, and there's some damage there anyway. The damage is about $6,000 to $7,000.
Sorry, 67 or 6 or 7?
6 to 7,000
yes.
to have because it's 10 metres up. You have to have scaffolding, safety, and all the rest of it. And I've spoken to the neighbour, and he's basically said to me he's not responsible for acts of God.
And I agree with him.
But it has dropped branches in the past. So I was looking it up. So he would have known that branches can fall from that tree.
No, we all know that branches can fall from the tree. Do we know that that particular branch was likely to fall from the tree? See, it's a question of, if you like, the unseasonableness of the wind. Was the wind 100 kilometres an hour? What was it that caused it to fall? I know it was a wind, but if it was, it's kind of like, was it a truly extraordinary wind or just a
A wind.
I don't know, ordinary strong wind, which sounds daggy, but there you go. Yep.
Okay, because it has dropped, like almost every year it drops a branch into our property because it's maybe because it's 20 metre frontage. The tree's overhanging 10 metres into our front yard.
You'd need to know the kind of tree, the likeliness that branches would fall. And my problem is I can see you spending $5,000 to have an argument over a $6,000 repair.
I think I'd take David's advice on that. Last call, let's squeeze one in from Ian in Dandenong. Hi, Ian.
Hi. Hello, David. Thank you for taking my call. I received a parking infringement notice on my car. However, it was addressed to the owner of a very similar vehicle with one different digit on its registration.
Yes.
Right. So they've made a mistake.
I don't know. I suspect so, but I don't know. I don't know
you have an infringement.
Where the process will go.
Well, the process will... do you have one of those new licence plates with the 6 digits of alpha and numeric?
Yes.
Okay, so the issue will be the system will show up that the number won't exist because I think they've got like an inbuilt formula in them so they'll know whether... So the answer would be, Ian, at this stage, I wouldn't worry about it, right?
Because you can't pay it because it won't when you try.
Oh, you can always pay it. That's so, Ian, they'll always take the money. Let's not be silly. They could take the money, but they won't be able... They'll start the enforcement process against somebody else. So if you want to help out your neighbour, Ian, pay it. Otherwise, what will happen if the parking officers now take photographs of cars they put tickets on. So they'll come and get you sometime. So when they'll ultimately work out that it's the wrong vehicle, they'll issue you a new infringement notice.
And they won't be able to charge you late fees because...
They haven't served you with an infringement notice.
They haven't served you an adequate notice. Thank you, Ian. Thank you, David.
Thank you for the last few months.
Are you a Rod Stewart fan?
I don't know. Yep.
Okay, so, you might want to just,
I should be listening to the program.
Listen carefully so that you can get in the running for a double pass to one of his concerts and then you can go along and you can see whether you like him or not.
Okay, thank you very much. So, yeah.
David Whiting there, and thank you, David.